Morning.
Morning, Banani. How are you?
The meeting will start soon. There are a few things that the chairperson is finalizing. He will soon join us.
Okay.
Are you with me?
Hello? Hello? Hello?
Hello, Chair.
Can you give me some? Can you give me some 5 minutes? Give me some 5 minutes. Hello?
Same here.
Hello? Hello? Advocate?
We can hear you, Mr. Chair. We can hear you.
Oh, I'm here. I want to apologize for keeping you waiting. I just had some little challenges here and there. Are you ready for us to start? You are most welcome, all of you. And I'm happy that you took the offer on Friday that we continue with our bilaterals. I want to believe that those bilaterals will have taken us closer to one another and to make progress in the best interest of South Africa and the people of this country. And as we agreed last Friday, we instructed the parliamentary legal services to produce a draft bill for our discussion. And I want to believe that we are not going to quarrel with what they are saying, because it's a proposal for our consideration. They are not imposing it on us, and therefore members should make contributions informed by their own positions or positions that emerged from the bilaterals. So I'm just saying that there should be no war with the parliamentary staff, because Mabula, myself, and those who are lawyers will know that lawyers do not always agree. So if you don't agree with another lawyer, there's no reason to cast aspersions on them or to accuse them of anything. It is their opinion, and they are entitled to their opinions, like we are all entitled to our opinions. So I want to then, with your permission, request the parliamentary legal services to make their presentation. Advocate Bonani.
Thank you, Chairperson. Yes, we have, in fact, good morning.
Chairperson.
Hello. Hello.
I wanted to call for your attention, yes. It's Floyd here.
It's quiet.
I've called for your attention, Chair. It's Floyd.
Okay, I can hear you. Please. I
wanted to propose that as a committee, we consider asking Parliament to give us an extension to have further deliberations on this process, because the bilaterals that we have engaged in have not yet produced a consensus in terms of how we are going to handle Section 25 of the Constitution. And so we don't have a foundational agreement yet in terms of what it should look like. So we're proposing that let's request Parliament to extend this process, and then we have further deliberations. And if in this last attempt we fail to have an agreement, we'll present a report that would have been agreed by majority to Parliament, and then we'll take it from there. But thus far, the bilaterals have not given us the outcome which we had anticipated will come out of it, because the very purpose of the bilaterals was to come closer to each other in terms of this process, and we have not yet gotten to that stage. And so in the interest of democratic engagement and consensus building, we propose that let us request that we allow space for further engagement until we have reached consensus in terms of what should be contained in the amended Section 25 of South Africa's Constitution.
With respect, Honorable Shibambo, I want to propose that that request come later, not now, because the bilaterals were not part of the committee proceedings. They were agreed to really manage the process in such a way that we give the parties an opportunity to consult internally, and the parties to consult amongst themselves. So we will come back to your request later, but we need to have on record what progress have we made or not made, so that we can identify the key issues that would justify the request that you are making, so that when we make a memorandum requesting the extension, we should be able to indicate why we need the extension, what are we going to do with the extension, what issues are in question. So I would then, with due respect to you and all others who may be thinking that way, request that we allow the Parliamentary Legal Services to proceed. Advocate van der Merwe?
Chairperson,
Thank you,
see-
Chair.
Yes, Dr.
the Honorable Soma has raised her hand.
Honorable Suma? Honorable Suma?
Good morning, colleagues. Thank you very much, Honorable Chair. No, I think I'll respect what you have made in terms of what was been proposed by Honorable Shivambo, that let's deal with it at the end and deal with the purpose. However, Chair, we must be mindful when we're going through what we requested legal services to do. By 11:30, we should have been done with that so that it can be 80 seats. Thank you very much.
Oh, yeah. Yes, thank you. So we'll request that yourselves who were in bilaterals, you quickly sum up the agreements and disagreements and motivate when we come to the request of the EFF for postponement.
Okay,
Advocate
that's fine.
van der Merwe?
Thank you, Chairperson. Thank you, members. I'm going to share my screen so that we can see the bill. I'm going to keep my video off, if you will allow me, just for bandwidth with purposes. Chair, I'm not going to go through the whole bill. I think the aspects that haven't changed, I need to not stop on that. Chair, and members, on page 2, we have here just added a general explanatory note. The reason for that is simply that the bill as advertised did not have any deletions. So then we don't have to explain that words in bold between square brackets indicate deletions. However, some of the proposals now are for deletions. So then we have to keep that in. So of course, once the committee has decided on what the bill will look like, then we will finalize this. The same in respect of the long title. We did not finalize the long title because also that will depend on what the bill will look like in the end. Chair, there were no proposals from parties in respect of the preamble. So I'm going to go down to clause 1. Chair, in respect of clause 1, there was a proposal from the Freedom Front in respect of subsection 1. That proposal was to make provision for a positive right in respect of property. In other words, to insert the sentence, everyone has the right to own property. And then we've just added then the sentence goes on as it is in the Constitution. So the proposal is that subsection 1 would read, everyone has the right to own property and no one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. Then just a drafting note from our side. This is not something that was advertised, and it's our view that the committee will have to, if the committee agrees to this inclusion in the bill, that the committee will have to advertise same, and that the committee will have to approach the Assembly for permission to extend the scope of the bill. Chair, may I just ask, do you want me to go through the whole bill, or should I stop at each of these proposals for discussion?
No, because at the end, there are going to be different views. Just go through the whole thing so that we know the state of affairs and where, for instance, as you say, there may be a need to go back to the House. I'll proceed.
Okay, thank you very much, Chair. Then so this little line that I've put there was just to indicate that it deals with one aspect. Of course, that line will come out of the bill once it has now been finalized. So the second aspect, this is something that was part of our bill as advertised. So our bill as advertised had the wording, that expropriation can happen subject to compensation, the amount of which, the time and manner of payment of which have been agreed to or approved by a court. And then the committee added this bit, provided that in accordance with subsection 3A, a court may, where land and any improvements thereon are expropriated for the purposes of land reform, determine that the amount of compensation is nil. On this, we have two proposals that we've included in this bill. The ANC proposal is that the word court, this in accordance with subsection 3A, is removed. Now, that is just a technical amendment. I have no concern about that removal. Removing the word a court. The committee will recall the concern here was that there's an interpretation possible that with the words a court there, that it may
recording in progress.
That it may be interpreted that the courts must be the first decision maker, and that was not the intention of the committee. So the proposal from the ANC is to remove the word a court, and then lastly, it is to define the phrase land reform as contemplated in subsection 8. Now, this came from the public as well. Chair, on these two amendments, the issue of court, deleting court, and explaining land reform, linking it to subsection 8. Our office, Legal Services Office, is of the view that because it could have been a misinterpretation in respect of the word a court and what the role of courts are, importance of this bill, that this amendment has to be advertised again. In respect of this contemplated in subsection 8, because of the importance of the bill, the nature of the bill, we would also recommend that that be advertised. However, the committee must be made aware of the fact that from the committee support section, there is a view that neither of these amendments have to be advertised. And the reasoning is, it is based on law, as the chair have indicated, so many lawyers, so many opinions. It is the committee supports argument is also based on case law. It's on the Truworths case. And they are saying that because this was proposed by the public, the committee does not have to advertise it. So if the committee agrees on this proposal here, the committee will have to just consider both arguments, the one for publication and the one against publication, and make a decision in that regard. Then there was also on the same aspect, a proposal from the EFF. And their proposal is that the whole of subsection 2 be amended, not just this paragraph B, as the bill did and the ANC is proposing, but that we move this part only in terms of a law of general application into the conditions part, and that it may be made clear that property may be expropriated without compensation. Now, just to make it clear to members, this portion in bold and between the square brackets, only in terms of a law of general application, will of course be deleted from the text. So that is what the proposal is there. We just have to include it in the bill because that is just how drafting convention works. The same here in respect of B. So the proposal from the EFF is that 2 must read, property may be expropriated without compensation for a public purpose or in the public interest, and only in terms of a law of general application. So our view is that this deletion here, the deletion of paragraph B, will have to be advertised and sent to the provincial legislatures and the National House of Traditional Voice Leaders. I'm just going to say consulted on because there's a number of aspects that has to be, all of the things where we say consulted on, it will be all of these parties that have to be consulted. So this is the second aspect. Then the third aspect that came up is the bill is advertised, indicated that subsection 3 be augmented in the sense that it now refers to subsection 2B and the time and manner of any payment. This is just consequential to make sure that we now indicate that sometimes there will not be payment. And 2B is, of course, what we dealt with above here, where we said provided where it is for land reform, the amount may be nil. So, Chair, there was no proposal from the ANC in respect of this regard or from any other party. The EFF proposed that the whole of subsection 3 be deleted. Now, subsection 3, just as a reminder to members, is the actual compensation clause, where the factors to determine compensation is set out. So that is their proposal. And then just it is our view that if the committee accepts the deletion of subsection 3, then this will have to be, in other words, the EFF proposal, that will have to be consulted on. And the next aspect is the insertion of subsection 3A. Subsection 3A provides that national legislation must set out, well, the bill is advertised set specific circumstances where a court may determine that the amount of compensation is nil. The ANC's proposal is that first off, we remove a court. It's the same argument as before. We don't want it to seem that a court is the first decision maker. They are the dispute. They are the institution that will resolve any dispute. They're not the first instance decision maker. And then also to remove the word specific in front of circumstances. Chair, so again, this is the same argument as before, where our office is of the view that this will have to be consulted on, the removal of the word a court. Specific, I don't think that is necessary for consultation, but a court, simply because of the interpretation challenge and the nature of the bill. However, the committee section is of the view that because this comes from the public and it was in the bill as advertised, it does not have to be amended. So if the committee accepts the removal of a court here, it must just consider the two views in respect of whether it has to be consulted on or does not have to be consulted on. Then, Chair, from here, we have proposals from the EFF for new amendments to Section 25. The EFF proposed, you will remember up here, the deletion of subsection 3, and then in their proposal, they've changed the numbering of the subsections. Now, unfortunately, drafting convention does not allow us to change the numbering. So what we do is the numbering of subsections must remain as it is. If subsection 3 is deleted, the consolidated version of the Constitution will simply have 3 and then a note it was deleted. But it will always remain that there was a subsection 3 that was deleted. So what we are suggesting is that rather than make it subsection 3, that it rather become something after subsection 4. There was also in this specific instance a proposal that this be made part of subsection 4, the paragraph C, added as a paragraph C. The problem is also that we can't add it as part of subsection 4, because then if you read the statement, land is a natural resource and the common heritage which belongs to the people as a whole under the custodianship of the democratic state. Now, this, in our view, is not something that is only relevant in respect of Section 25. I think the statement that is proposed is something that is a statement that the EFF intends to be part of the Constitution, and this would be something then that the Constitution will build on as a whole. However, if we put it as part of subsection 4, it is only applicable to Section 25, and I don't think that's the intention. So our proposal is that it rather be a new subsection 4A. So that is just a slight change that we've made from what the EFF proposed. We are of the view that because this is extending the scope of the bill and because this was not yet consulted on, that this will have to be consulted on and that the House will have to be approached for an extension, for permission to extend the scope of the bill. The next proposal from the EFF is in respect of an amendment to subsection 5. And again, they propose subsection, this now be subsection 4. But of course, as I've explained before, we need to keep the subsections as they are. So the proposal here is for this portion between square brackets to be deleted. So this portion within its available resources to foster conditions which enable to be deleted. And then we say which enable state custodianship and for citizens to gain access to land. So Chair, oh, sorry, I just see a mistake here. I just want to actually correct it before I don't want something to now go through if we decide to adopt it. So the proposal from the EFF is that subsection 5 should read, the state must take reasonable legislative and other measures which enable state custodianship and for citizens to gain access to land on an equitable basis. Again, it is our view, because this was not part of the bill as advertised, that it will have to be consulted on, and because subsection 5 was not part of the bill as advertised, that the committee will have to approach the Assembly for permission to extend the scope of the bill. Then the EFF also proposed an amendment of subsection 7, same situation in respect of the number. I'm not going to repeat myself. The deletion of the date here is proposed by the EFF. And again, just to remind members, the fact that it still appears there doesn't mean that it will be in the consolidated text after this bill has been passed and assented to. It is just that we have to do a deletion in this way, where we put it in bold and between square brackets. So the proposal from the EFF is that subsection 7 should read, a person or community dispossessed of property as a result of past racially discriminatory laws or practices is entitled, to the extent provided by an act of parliament, either to restitution of that property or to equitable redress. Chair, apologies. Again, because this was not in the bill as advertised, we would recommend that this be consulted on, and also that the committee seeks permission from the House to extend the scope of the bill. Then the last proposal from the EFF as well is in respect of subsection 9, and this is that Parliament must enact the legislative referred to in this section, rather than to say subsection 6 only. So in other words, any other referral to legislation would then be would become an obligation. So for instance, if I can just go to 7, where we say to the extent provided by an act of Parliament, this will then become an obligation. Chair, again, because this amendment was not part of the bill as advertised, it would be our recommendation that this be consulted on, should the committee, of course, agree that this must be in the bill, and that there be a request from the Assembly to extend the scope of the bill. And then the short title, there were no amendments. Chair, on the memorandum of objects, we did make this the same, you just repeated the proposals, but of course this will now change depending on what the committee decide to adopt or not adopt. Chair, that is what we have done on the bill. These were the only proposals we received, and we hope that we have reflected parties' proposals correctly as they intended it to be. Thank you, Chairperson.
Thank you, Advocate. Before I open the floor, I just want to request you to help here, because in the past meetings, we said that our democracy is both representative and participatory, which means we as parliamentarians don't have the monopoly of wisdom. We have to go to the people and find out what the people are saying. And the people said something about, for instance, subsection 25(7). Are we saying that we ignore what the people are saying because it was not in the published bill? And are we also not recognizing the fact that the published bill was a compromise? If you can just refresh our memory as to what is our position on that, and then I open the floor.
Thank you, Chairperson. No, as we've explained last week, in our opinion, this committee may make amendments to this draft bill. The only thing is that the committee must follow legislative process as set out in the Constitution and as set out in the National Assembly rules. So if the committee, and of course, it would be absolutely unacceptable if this committee paid lip service to consultation with the public. The committee must consider what the public has said. It does not mean that the committee must accept everything that the public said. There would be many things that this committee, in fact, during deliberations, has already indicated that the committee does not agree with it. For instance, there was proposals from the public that the bill itself should set out the circumstances Now, if I look at the proposals from the committee, and if I consider the deliberations of the committee, it is clear that the committee is of the view, or in fact, from the proposals made, it is clear that those parties at least are of the view that it should be in national legislation. Doesn't mean that the committee did not consider it. The committee did consider that, and the committee must consider everything that the public says. So if the committee decide to make amendments that were not part of the bill as published, it is simply a matter of that we must comply with section 74(5) so that there are further consultations. That is also echoed in the National Assembly rules. And then the National Assembly table advised that the committee should seek permission to extend the scope of the bill. So this is simply something that is in the National Assembly rules, it is because the committee is an extension of the House. The committee is given a certain mandate, and if the committee then wants to make further amendments extending the scope of the bill, then the committee asks for permission. And this is applicable to every single bill. It is applicable to executive bills. It is applicable to committee bills, to private members' bills. It is not. None of these rules are specifically applicable to this bill. Of course, section 74(5) is specifically applicable to constitutional amendment bills. And this is then, of course, a constitutional amendment bill, and we must comply with 74(5). So yes, Chair, you must take into consideration. The committee has to decide whether it agrees or disagrees with what the public said. If the committee decides it agrees with what the public says, then we must make an amendment to the bill. And if, of course, there is then a need for further consultation or for a need to ask for permission to extend the scope of the bill, then that must be done in respect of legislative process. Thank you, Chairperson.
Thank you. Honorable members, I'm not going to turn this meeting into bilaterals, but I will allow members to comment. And I think we have 15 minutes for the comments. And then from there, we look at the proposal by the EFF in the light of what the parliamentary legal services are saying regarding asking for extensions and following rules and things like that, so that all these comments must be taken into account. But from my standpoint, I think that are we still together? Are we still together?
Yeah, yes, Honorable Chair, we are.
We can hear you.
Yeah, but from my position, I think that parliamentary legal services have done a fantastic job, which in case we agree with the postponement, we will be able to engage, bearing in mind what the law and the rules of parliament requires, so that we don't come back with further excuses. Thank you very much. Honorable members, the floor is open. I see Honorable Gumede, Honorable Shivambo, Honorable Lesuma, Honorable Gaba, in that order. Proceed, Honorable Gumede.
Hello, Chair.
Yes, you are most welcome.
Good morning to you. I've got the leaders here, Chair. Lesoma was the first one, because I wouldn't like to take her position as well. If I may come after them, then I'll make my contribution, Chair.
That's very...
But good morning to everyone. I'm sorry for that.
No. You are perfectly right. Honorable Lesuma. Honorable Lesuma.
Yes, Chair. Yeah, thank you very much. Good morning once more, colleagues. I will say correctly, let's appreciate the good work that has been done by the legal services with a very interesting meeting that we had last week. That's one. Two, Chair, I would request two things. That if you recall last week, the ANC, when we requested Honorable Klaba to read for record paper or audio record purposes the ANC position in terms of the proposed text, we couldn't capture all the things that he has to say. And then it required me during the weekend with the legal services to communicate to and fro to make sure that they are clear in terms of the ANC position. If for 5 minutes he can be allowed to do that, and then we request quickly, then thereafter we request Honorable Shivambo's proposal to repeat it, then I'll come in and respond to it because I was eager to respond to that. Thank you very much.
That's fine. I hope members are happy with that because closes a very important gap. Proceed, Honorable Kaba.
Thank you very much, Chair, and good morning to the colleagues. May I request the legal section to go to page 3 of the document. The first proposal of the ANC. It's under section 2B. All right. May I suggest? Let me just read the proviso. Provided that where land and any improvement thereon are expropriated for the purposes of land reform as contemplated in subsection 8, the amount of compensation may be nil. May I suggest that you remove before purposes, purposes. In other words, for purposes, yeah, just remove that. All right. So then we go to 3A, capital A. Because we have deleted in our submission the phrase all right. Before we've deleted from section 2B, the phrase in accordance with subsection 3A, we've deleted that, right? So we now want to link 3A with 2B so that the two talk to each other. All right, because as it stands now, it doesn't give it's meaningless in the sense that it doesn't tell that it still refers to land reform. We are adding that for just before at the beginning of the sentence, just move at the beginning, at the clause, beginning of the clause. All right, we just write for the furtherance of land reform. And then you bring, yeah, thank you. All right, for the furtherance of land reform, national legislation must, subject to subsection 2 and 3, set out circumstances where the amount of compensation is nil. Yeah, no, right, it's fine. Then we go to 20 to subsection 4. Just go to subsection 4. I don't see that we've, okay, that so where I can see where it means that even our section would be 4A as well.
Okay.
Otherwise, it was going to be 4C, but you said, no, we can't make 4C. Instead, we must make, because it's a new insertion or a new clause, it must be 4A, all right?
Indicated that although we do not.
Okay, it's a new clause to read, the land belongs to, and is the common heritage of all South Africans. All right, and then we go to 5, subsection 5. Subsection 5. All right. So the ANC's position is that we retain section 5 as is, maybe you can just go down, copy the section 2025 5SEs. I would indicate where we're introducing changes. Just take it, take the EFFs one, or you've taken it. All right. But bring in, don't remove the within its available resources to foster conditions. All right. So in other words, all we are doing, we are just adding a phrase. We're just adding a phrase, state custodianship of land. Where is it? I don't see that. Oh, all right. State custodianship of land. And for all, right. Sorry, just remove for citizens. Yeah, for all citizens. Yeah, no, it's fine. For all citizens to gain access to land on an equitable basis. All right. And then we'll stand at that for now. And as the ANC, you may then comment whether it's in terms of drafting style, it's consistent with is consistent with the structure or the contours of the bill as a whole. So you would leave that to you when you make a comment on our submission. So for now, we'll just we've presented this as a ANC position that will be published, subject to whether we get another day or another weeks or months for further discussion on the issue. I would just want to leave it at that for now. Thank you so much, Chair. Have I lost you, colleagues? The room is so quiet.
No, the chair has lost you. The chair has lost you.
Or the chair has lost us. Hello, Chair?
Oh, I muted myself. I'm with you. I followed everything that you said.
Okay, thank you so much, Chair.
Yeah, Honorable Lesoma.
No, Chair. I think I've been covered to that, but I will request, because when Honorable Shivambo earlier on presented the recommendation of an extension, I just joined when he was about to finish the two words that he was talking to. So I didn't hear the starting point, so that when I come in his proposal, I'm clear what I'll be responding to. Thank you very much.
We are not yet there, because we passed it. He will have to repeat it for the record purposes, because it was prematurely raised, in my view.
Okay. Other than that, Chair, other than that, then I'm happy what has been presented by Honorable Baba, Chair.
Okay, Honorable Gumede. Honorable Gumede. Honorable Gumede.
No, he's fine, Chair.
He's fine.
Chair.
Okay.
No,
Honorable Gumede, yes.
Yes, Chair.
Yes.
So thank you very much. And may I formally then greet the Chair, the presenters, and the colleagues.
Thank you.
Chair, I've taken into consideration that there are much more kind of remarkable whether amendments that we want to effect, and we still need to kind of consult public, go to parliament. May the presenter guide us in this instance, because it can't just say, this is what you need to do, this is what you know, it's what is needed in terms of time. Because if we need to consider that as a committee, we must have been guided by legal, that all what she has said to us, does it require time, or within the time given, we can do it? Guidance from that aspect it's very crucial for me. Thank you, Chair. I'm covered then on other aspects. Thank you very much.
Now, Honorable Gumede, you have raised a very critical area for our consideration, because that's why I was saying asking for extension before discussion would be, with respect, premature, because we would extend and not know for how long. But your intervention will help us get indication as to, if we extend, what is the reasonable time for such an extension. And once again, thank you very much, Honorable Gumede. Honorable Shivambo.
Chair, I don't know really what we have to say now, because we have taken resolutions, I think 3 times now in the committee, that we are going to amend the entire section 25 and taking into consideration what members of the public have said. And the legal office is persisting on strong arming us into consultation and everything else there, because that decision has been taken already, that we think we have done enough consultation. Why can't they just present what we have said, like, without trying to lace it with all these other things, which is their positioning anyway, which we have rejected. We've rejected the proposal of consultations because we think we've dealt with consultation. That is what we have done in terms of the process thus far. Why are they strong among us? They're not politicians. They're not elected. We are the ones who are elected to deal with this process in our own wisdom and view, and in our own legal basis and foundation. We say that we can amend the entire section 25 in terms of what should happen. Why are they strong arming us? Like, if they don't want to do the work, if their principles disallow them to agree with what we are saying, they must just step aside and then we do it ourselves. That is what we have resolved on this issue. Why should all meetings we discuss the same issue time and again, go consult. When we've consulted, we say we have consulted, and what we're expressing here is a reflection of the consultations that we have taken from the people. That is what we have said. Why are we being strong-armed now? What kind of legal advice is this? It's no longer a legal advice. It's political interference with this process. Let's discuss these things without even considering that aspect of consultation, because that question has been resolved and we've put that aside. Now, the issue, which of course is linked to what I said earlier, is that ourselves as the EFF and the ANC are in the process of discussing the issue of custodianship of the 1913 and the issue of what words do we use, whether it's nil compensation or expropriation without compensation. And those are the areas that we're discussing. And we have not yet found consensus amongst ourselves, because it's not like we're engaged in some secret discussions. We're engaged in these discussions openly to say that if we find consensus, we're going to then vote in Parliament to have the 2/3 to amend the Constitution. And we're pleading for the committee to consider that we have a postponement of this process until we've found each other on this process, and we'll take it from there. But this thing of being strong-armed is actually very problematic. And I maintain that it is bordering on misconduct now, because we have taken a resolution as the committee, but every time they open their mouths here, they always want to force feed us their version of how we must handle this process. Even when we've resolved that, we don't accept that version. We can't be force-fed things here. We must be allowed as elected representatives. We represent people who didn't apply for these jobs, who were voted into this office by the people of South Africa, by millions of South Africans. And the mandate was very clear in terms of when we voted that we're going to expropriate land without compensation. We must not be strong-armed into things that we have already resolved on, and then we're made to do something else. When we agree on this, we're going to present a report to Parliament. If the legal office wants to go to court or do whatever, they let them go to court. We'll go and defend ourselves in court to say that we think that the consultations that we had were adequate, and all members of the public and oral submissions and written submissions have reflected on the entire section 25, which we are now amending. And we don't think that there's anything wrong that we did in terms of finalizing this. And if the court rules otherwise, we will then look into it in that particular context. The plea, Chair, is that let us postpone this thing and then we will come back to it once we have reached consensus. There's a possibility, there's a scope for consensus thus far in terms of what happens, because although it is not yet clearly and cogently stated, the now revised section of the ANC on subsection 5 looks into the issue of custodianship. We just have to then deal with those issues, and then we'll then come back to adopt the report once we have found each other. And there is a scope for us finding each other on all these questions, and then we'll take it from there. Thanks, Chair.
I have noticed 3 hands. Honorable Gumede, is that an old hand or a new hand?
Hold on, Chair, I'm sorry.
Okay, then I have Dr. Melda and Honorable Lesoma. But before I allow them, and Honorable Kala, I just want to set the record straight. With due respect to Honorable Shivambu, we as democratically elected members of parliament have the right to decide. But our right to decide must be exercised within the law. So what parliamentary legal services are doing is to guide us on whether or not our decisions are within the law, the constitution, and the rules of parliament. So I would not agree that they are strong-arming us and that there is political interference, that there is misconduct, and that they must step aside. I would not agree with that, because as a lawyer myself, I may take a different view from them, or I may take the same view, but this is not the platform where my views matter. And other lawyers may also agree with them or differ with them, but this is not the platform to check what other lawyers are doing. All I want to say is that there's no strong arming, there's no misconduct, there's no political interference, there's no need for anyone to step aside. But I want to agree with Honorable Shibambo on the fact that he says there are areas where the EFF and the ANC want to engage. Those areas include whether we use the phrase without compensation or nil compensation. And the other area is the area of custodianship, state custodianship. What would be the scope of that custodianship as opposed to nationalization? And the other area is the question of the 1913 cutoff date. So I think Honorable Shibambo here has done what I suggested, that if we consider extension, we must justify extension to do what? And I think he has started to take us in that direction. And he added that he thinks that there is a scope for consensus between the EFF and the ANC. But I want to add that this is not an EFF-ANC process. It is a process of parliament, it's a process of all the parties represented here. So I will suggest that we put it in that way, that we are going to consider the views of other parties, so that the consensus must be a consensus amongst all the parties in parliament, or some of the parties in parliament. Thank you very much. Honorable Dr. Melda.
Yes, thank you, Honorable Chairperson. If we were in the House in the debate, I would have said here after your intervention with regard to legal services. I absolutely agree with you. You're absolutely correct. Chairperson, I have a little bit of a difficulty. The proposals made by the ANC, by Mr. Kaba just now, and the amendments that the ANC now proposes, none of the other parties, maybe the EFF, but none of the other parties have had seen this before a few minutes ago. So obviously we couldn't consult with anybody with regard to those proposals. I would specifically like to ask some clarity. There was a proposal with regard to subsection 5, which says to foster conditions which enable state custodianship of land. I would like to understand what that means. Subsection 5, to foster conditions which enable state custodianship of land. What does this mean? I don't know. Then, Chairperson, with all due respect, you referred to section 25.7 and the 1913 cutoff date, and then you said the people said. But with all due respect, Chairperson, the people said many other things as well, even with regard to section 25.7. So I think it's stretching a bit far to say the people said. The people said many other things during this whole process. Then, Chairperson, with regard to the things that were said by Honorable Shivambu, it's not new. Mr. Shivambu has said them in the past. We can't operate. We're not an anarchy. We're a constitutional state. We can't operate to say the committee decided this or that. We can't do that because the committee is an extension of Parliament and we as members are bound by the provisions of the Constitution. It's not a question of just saying this or that and that legal services should step aside. It doesn't work that way. We are bound by the provisions of the Constitution, section 74.5 and others, as well as the rules of Parliament. The last point I would like to make, Chairperson, is that we've got a problem in terms of the resolution adopted by Parliament that gave us this mandate. That mandate expires today, the 29th, the 31st of May. It's today. So that mandate expires today. So whether we like it or not, either we report back to the House today or the mandate of the committee falls by the wayside. So I understand that if some of the parties have a need for further bilaterals, that may be so, but I don't think we can report to the House that one or two parties want to have bilaterals. We need to report something in terms of a mandate by the end of today. And if I listen to the Honourable Lesoma, we've got a deadline to make the ATC by 11:30. Thank you, Chairperson.
Thank you, Honorable Melda and Honorable Kava. Honorable, yes. Yes, proceed.
Oh, can you hear me now?
Yes.
No, thank you very much for the opportunity. And we did indicate in our bill that we did indicate that the ANC believes in mixed land ownership, private, state, communal, ownership. So the land, as the state as we are talking, is acquiring land, for redistribution. The land that the state has acquired currently is in its state custodianship. So it's unavoidable that the land, as and when the land is acquired by the state or expropriated, whatever means, it will be in the custodianship of the state until it has been redistributed to the beneficiaries. So there is a period between acquisition and redistribution. So what do you call that stage between acquisition and redistribution? We call it custodianship. That's one form of state custodianship. And the second form of state custodianship is what already exists, Dr. Mulder. There is land that is in the state custodianship, communal land, for example. I'm sure you'll agree with me that communal land is in the state, is under the custody of the state, but administered by the traditional or authorities, as it were. So I'm sure you'll agree with me that this is not a new concept or a new thing. it already exists. And but we, as we said previously, our intention here is to make explicit that which to make explicit which is implicit. I'm sure. Let me just check if Dr. Mulder has got what I was trying to put across.
No, Honorable Baba. You have put across, I think, in clear terms.
In clear terms, thank you so much. I thought I was missing. People would misunderstand me. Thanks.
No. Honorable Lesoma. Honorable Lesoma.
Yes, Chair. Thank you very much, Honorable Chair and colleagues. I will start by saying that by no means that we want also to persuade each other at this meeting level. However, for the ANC, it's very important that we must record to the FF Plus that the last time we met, we said we must meet immediately. And that immediately, unfortunately, didn't come immediately. That's a demonstration that, as corrected Dr. Mutla said, that there is some modification of the ANC submission that Honorable Kaba have read now. That proves and bear fruits that the continuous persuasion of each other. Mind you, ANC was not only having bilaterals with the FF Plus, we did declare that. So as we move along, then we try as much as accommodate everybody's views, but also for the reason of the South Africans, not for the political party reasons. That's one. I thought I must just record that. It's not because we were engaging with you in bad faith. It's just that as we move along, so we also reflect on our suggested text, as it were. Two, Chair, whatever probably we might have said is through frustration because we have been correctly so extending our life more than what will be viewed by South Africans that were stringing them along. But as a true demonstration that we are not only, we don't want also to come with a half-cooked baked product based on the mandate, but we ensure that at least there is a meaningful change in the Constitution to ensure that the redress of the imbalances of the past in terms of the land ownership is achieved. That's three. Hence, Chair, I would like, based on the reasons that Honorable Shivambo have put forward, but also if you read very carefully the legal advice submission, as it were, it says that we must also prove beyond reasonable doubt that we have incorporated the views of the public. And we want also to just to tweak that one so that when we come to the final, or we agree with all parties that we are having bilaterals with, also we have satisfied ourselves, because by the way, we do have our own lawyers and other parties do have their own lawyers, that in our own legal standing, based on our legal advice that we have received as an organization, we have checked all the nuts and the bolts, as it were. Hence, I will agree and support and move that the report must contain one, which is already there in terms of the report, in terms of both public participation, which is threefold, which is your written submissions, your public participation, and also public hearings, and also your oral submissions, as it were, which we concluded that report, which means the report is there. The only thing that was missing now was then to insert the actual text, which we are saying in support of the EFF, is that we feel that if Parliament can give us just 30 days, or if you use the normal word, it's 1 month, we would have find each other or agree that we are not finding each other, then we present the report to the House, which is conclusive. It's not because we want our lifespan not to be an open-ended one. Hence, I'm supporting that with the reasons that I've put forward, Honorable Chair. Thank you very much.
Thank you, Honorable Suma. You ran a little bit ahead of the chair. Because
I wanted to add one thing.
Yes.
Yes. No, I forgot to add the following, Chair, that redistribution is different from restitution, in the sense that with restitution, you take land from A and you give it to B. In other words, you take land from the owner and give it to the claimants. But with redistribution, you acquire land, hold it until you redistribute it. So it was in that context that we must provide for custodianship in that sense. Thank you so much.
Thank you. Now, honorable members, before we formally deal with the request of the EFF for an extension, because it has got to be formalized, I just wanted to note that Honorable Dr. Mulder says there are some proposals which they didn't hear before. So please make sure that they get those proposals. And Dr. Mulder, I agree with your criticism of the chair. When I said the people said, you said no, but other people said other things. You are right. I was just referring to the dominant view, but that's unfair because all views, whether by a few or by the many, they deserve attention. So I agree with you. I think that Dr. Lodrich has a hand up. Let's take a hand before we proceed. On the Honorable Lodrich.
Thank you, Chair. And good morning to everyone. Add our voice to the fact very, very problematic if we should now have to take any decisions based on new matters that are included. We all know that we do work with specific mandates, and the matter of custodianship is something that we will have to look at. It is much more complicated than is put to us, and I think there are many things that we still have to discuss. So I cannot see us in any way today taking final decisions.
Dr. Ludrich, I think you agree with everybody. That's why there was a proposal by the EFF of an extension. That takes account of your concerns, which I think we all should agree with you. Now, honorable members, I want to ask the EFF to formally put their request for an extension and also indicate the areas which, in their view, are outstanding, which will form the menu for the bilaterals that will follow. Honorable Shibambo.
No, thanks, Chair. As we have stated earlier, we are proposing that there should be postponement of this process so that we can continue with the engagement here in the committee and, of course, in bilaterals to discuss the issue of without compensation vis-a-vis the nil compensation proposal that is in the draft bill. And then two, to then deal with the issue of custodianship in terms of how do we include it in the amended section 25. And then the last aspect of these further deliberations will focus on the cutoff date for restitution purposes. So those are the three major factors that we think that there's a scope for a consensus that can be built, and we have not yet reached consensus on that. So let us further deliberate on it until we have reached consensus so that we can present to Parliament a comprehensive final amendment which is agreed to by the majority of Parliament. That is consistent with the 27 February resolution of Parliament in 2018 in terms of custodianship and expropriation without compensation. That is solidly our proposal that let us postpone this for further deliberations.
But for how long? For how long?
We propose that we must be given an additional 60 days.
Honorable Dr. Lodrich, what are your grounds, specific, not in general? What are the grounds for your support for the postponement, and for how long?
Chair, we are in support of a postponement, and I don't think 60 days is problematic for us. However, I am concerned with the fact that it is very prescriptive and focuses only on EFF proposals made in this committee. I would honestly say that the reason for the postponement is to deliberate further on matters. I don't think we have to get to any consensus or stated that we want to get consensus, and I don't think that we should be dictated to in terms of what we have to discuss during this.
Dr. Lodrich, and I don't think that the EFFs are dictating. They are isolating the key issues in their view. So you are free also to indicate your issues. But if you are not ready now, then during the bilaterals, you can raise those issues. Are we together? Dr. Lodrich?
Extension. Chairperson, yes, but I still have a question whether those matters should actually be in this proposal. But in any case, that we've stated our case.
Okay, do you want to mention those matters?
Chair, I think the matters that we have to discuss are any proposals that were submitted today, because we do not have had sufficient time to obtain our mandates on that. So I would prefer that it be a general matter and a general reason why we postpone.
Okay, thank you very much. Honorable Lesoma and Honorable Kaba. I saw Honorable Lesoma first.
Yes.
No, Honorable Chair, thank you very much. Let me just start by, before I say the actual substantive matter that I raised my hand for, that colleagues must mind also that we are this week going immediately for recess. So
No, Honorable Lesoma.
No, Chair.
No.
Yes, Chair.
The first thing is there was a proposal for the extension. I want to see if there is support for that proposal.
As a principle,
and for how long?
Okay, yes, that's why I was laying the foundation, Chair. My apology. Probably in principle, we support the extension as the ANC. I would, before I say this, no, I'm going to the how long now. Allow me to lay the foundation on the how long. Okay. Thanks, Chair. Is that honorable members might be mindful that immediately end of this week we are going for recess. So the extension is neither here nor there. Hence, I would like that we go and find a middle way of 30 days so that we don't have a very long unreasonable, because from now, if we agree with 30 days, we will sit and not sleep 24 hours to find each other, so that within 2 weeks of expiring of that 30 days, we have concluded the matter, and you know that at the committee level it's a smooth running. Thank you very much, Chair.
You were saying there are some substantive issues you wanted to raise. Honorable Suma?
No.
Okay.
I've done it. I've dealt with everything. So I've put a proposal with a motivation, which is slightly in terms of the actual days or months, shifting from the 60 days that was generally asserted. And I'm motivating the rationale thereof of 30 days, Chair. Thank you very much.
Okay, thanks very much. Honorable Kaba?
Yes, Chair. Thank you so much. I just want to refer to our 25.5 legal advisor. We say, yes, just Charmaine, 25.5. Okay, no, just 1 point, Chair. Just 1 point. Or you've removed, can you remove all, please? That all on page 7, that all. Thank you so much. That's the only character I wanted to remove. Otherwise, it was going to spin the whole thing. Thank you very much.
Okay, fine. Honorable Mahlatsi? Honorable Mahlatsi?
Thank you very much, Chairperson, and good morning, colleagues. Chair, I want to support the proposal by Comrade Honorable Lesoma on the 30 days, primarily because we have managed in the past 2 weeks to interact with one another and to a large extent be able to share views amongst different political parties. I don't see, as I think all of us in this committee, we've got all the intention to bring this matter to finality. And therefore, we should be able to take this process quite seriously and be able to put everything aside so that we finalize it. 60 days seems to be pushing it too long. I support the view that we should stick to 30 days and be able to finalize this process. Thank you, Chair.
Honorable members, I don't want us to take arbitrary decisions. As I said earlier, our decisions, we have the right to decide, but our right must be exercised within the law and the rules of Parliament. And therefore, I'm going to ask Parliamentary Legal Services, in the light of issues which they think would need consultations, what is the timing for that? I'm not saying that I necessarily agree with what they say about going back to Parliament and so on, but I just want them to give us an indication on the timelines before we finalize this matter. Honorable, Advocate van der Merwe.
Thanks, Chair. Chair, the timelines is actually not something that legal advises on, but I have been in contact with Mr. Vonani Romano, the committee secretary, and he has indicated that there will have to be, if the committee decides to advertise anything, he would suggest 3 weeks for that, and then 2 weeks for consideration of the submission. So his proposal would be 2 or 3 months for the whole process, if that includes advertisements. Chair, if I can just make one observation for the committee to consider. If the committee asks for an extension that will end during recess, the committee will not be able to get the House to extend if let's say the committee asks for 30 days and it then decides to advertise. The committee will not be able to get a decision from the House before the 16th of August, which is when recess ends. It's quite a long recess this year. So I would just suggest that the committee also keeps that in mind. So any deadline that is given, the House, or not any deadline that is given, any extension period that is requested, if the committee wants the House to make a decision on whatever it reports, then that decision can only be made after 16 August. So maybe just to summarize, Vonani indicated, committee secretary indicates that 60 days should be sufficient. And like I've just said, the committee must just keep 16 August in mind for any decisions that it might want from the House. Thank you, Chair.
Is it not possible to get a special sitting of Parliament?
Oh yes, there was in April, Chair. We've had some special sittings of Parliament. So yes, it is possible. But the committee must just then keep in mind that is a request that have to be made. I think it's much easier now that we are sitting with virtual sessions. So it is possible, yes.
Yes, you see, as we sit now, there are land invasions which are raising conflicts within society. And this is negatively the efforts of government to create a socially cohesive and prosperous communities. And it's also delaying progress because we have, as Parliament, adopted the social and economic recovery plan. And the implementation of that plan depends on the resolution of the land question, because you can't say people must go and build a new economy if they don't even have a place to stay in. So if we are able to get a special sitting of Parliament and the whole question of land arose in June, I think that I think we should settle for the 30th of 30 days and use June to do the work, and then ask Parliament to have a special sitting to finalize this matter, because we may lose control over the people unless we address this matter urgently. So that would be my view, that we accept the 30 days, because when I look at the issues that have been placed on the agenda, those issues are not many, and they are not as complex as we may think. And I don't even think that some of these issues would require us to public and go to public hearings. So can we agree on 30 days and agree on a special sitting of Parliament? Honorable Kawa, Honorable Lesoma, Honorable Nuku, let's not raise new debates. Let's talk about what I've said.
I want to check with the advocate whether we cannot, in the same report, ask for permission to go on the consultation process, so that if Parliament says yes to the resolution, it says yes to granting us the extension, and yes to publicizing, am I right? Publicizing or publishing?
Publishing, yeah.
We are publishing the new amendments, so that we don't have to wait, we don't have to come back again. We now know that there will be fresh amendments. Thanks.
Well, thanks for that innovation. Honorable Lesoma.
No, I would like to step over, Chair, because your summary and what covers everything, because it doesn't mean that Parliament, when it's on recess, it has shut down its doors. The work proceeds as long as you have set it up front that you will seek a permission and be granted to do 1, 2, 3. And I think it is appropriate in order. Thank you very much.
Thank you, Honorable Nuku. Nasipa.
Thank you, Chair. Chair, just listening to the legal services, how they outline what needs to be done, I do agree that maybe looking at 60 days will be reasonable, because I think 30 days we might find ourselves in the space that we are in right now. I think let's just, as Honorable Lotred said, that, let's just make sure that, we tick all the boxes that we need to tick, and ensure that, it's not really to address one political party. It is obviously, to ensure that we run the process smoothly. Yeah, that's my contribution, Chair. Thank you.
Thank you. Honorable Hudson.
Thank you very much, Chair. Yeah, Chair, I think the process that we have undertaken has taught us some serious lessons in terms of how meticulous we need to be in as far as this process is concerned. However, as we have outlined and as you have summarized, I think we ought to be mindful that it will be for the, if not the third, the fourth time this committee's mandate being extended. Now, to extend beyond the 30 days, in all honesty, where there is a possibility of us being able to finalize the work within a reasonable time, in line with what
because 60 days.
Honorable Soma, please.
Honorable Soma, today you are not chairing. Thank you.
Chair, I'm saying, given that there's a possibility of us requesting for a special sitting, and we be able to finalize this work within that period, honestly, I want to submit that we stick to the 30 days and move along that line. Thank you, Chair.
Thank you, Honorable Mahlazi. Honorable Lesoma.
No, my apology, Chair, my humble apology. I didn't say that my mic was
no, don't worry. I've done that as well many times. So you are just a beginner in that. Proceed.
No, thank you very much. No. I think without the ANC repeating itself, the summary and the motivation, Chair, for me, I'm fine with it. Because we cannot be fighting for more than 30 minutes for just 60 days and 30 days. Thank you very much.
Thank you. Honorable members, thank you very much, because even asking for this...
Sorry, Chair.
Yes?
I did ask the Charmaine.
No, I'm coming to...
Thank you so much. Thanks.
Yeah. Honorable members, I just want to say before Charmaine comes to that point, to say that even the 30 days we are requesting is really a request. And one would even say an unreasonable request. So we shouldn't stretch it too far. We can't go beyond the 30 days. And I think that the innovation that Honorable Kaba introduced is a very useful innovation in terms of the uncertainty of what the response of Parliament will be, so that we have the whole package of all that we want to do. But let me allow Advocate Charmaine to address us on that question raised by Honorable Kaba.
Thank you, Chairperson. May I request to pass the buck, though, to the committee secretary? What can and can't go in a committee report is something that Vonani would be much more mandated to speak to. I have my personal view, and that would be to support what is proposed, but I don't want to speak for him. That is not something that we have a mandate on. So if I may ask, if Vonani could maybe just assist the committee on what the report may contain.
Advocate Rama, Rafa Normeves, pass the buck to you. Don't pass it further on.
Yes, Chair. I was tempted to pass it over to Advocate, but I'll attempt to answer it. I think that the committee can ask for permission to publish the amendments. I think maybe one issue that I was going to raise was that the committee must decide if it agrees with the opinion that certain amendments must be published for further comment. If the committee agrees that amendments have to be published for further comments, then when we request an extension, we'll request an extension to a specific date. And we also ask for permission, maybe to extend the mandate if the committee feels that we're extending the mandate. We can indicate that we want to cover X, Y, Z, and that also we also request permission to advertise those amendments for further comments. Thank you, Chair.
No, honorable members, my view is that we shouldn't do anything that will force us to go beyond the 30 days. Because this question of the need to publish and so on and so on was really to cover our back. But in covering our back, we mustn't open ourselves to longer extensions, and we should stay with the 30 days. Anyone who wants to comment on that? Anyone? Dr. Melvin? Yes.
Chair?
Yes. Dr.
Please grant
Advocate
Charmaine, please.
No, I see the hand of Dr. Mulder. I still want to deal with the politicians. Dr. Mulder?
Chairperson, no, I need clarity in terms of what we are doing at the moment. What are we going to report back to the House and get into the ATC within the next 30 minutes? It's just going to be a small report that says the committee requires an extension. for 30 days, full stop? Or do we have an elaborate thing and that this proposed new amendment bill, etc., all of those will be published? I just need clarity. Thank you.
No, I think the committee secretary will help. My view was that we will do a memorandum requesting the extension. The memorandum should state the areas where we still seek further engagement, so that it would not be reported as such. But let me leave it to Advocate Charmaine to answer the question put by Honorable Kaba, and then go back to the committee secretary to guide us as to whether it's a report or a memorandum. Thank you. Advocate Charmaine.
Chairperson, I hope that I'm answering the right question now. What I said was, why I asked Munani to answer is because I'm not sure what is allowed to go into a report or not. But from his answer, I can gauge now that the committee may, in this report that it's going to do to the House, whether it's a memorandum or a report, may request sorry, I'm also just looking what Vanani is saying, may request that the additional amendments that the committee is currently considering, that it may proceed with that, and if necessary, advertise it. I understand that may be part of this report that the committee will now consider. I hope that answers the question.
Okay, on Advocate Ramano. Advocate Ramano.
Yes, Chair. Now, in the past, we have used a memo to the Speaker requesting for an extension. So that is the proposal that I was going to table for the committee.
Okay. So, honorable members, we are going to go through by the way of a memorandum, and the period is 30 days. And then we also are saying that we will need a special sitting of Parliament, because this matter cannot be dragged further than we have done now. Honorable Lesoma, do you want to say something?
No, Chair, I just wanted you to see my face. That's all. I agree with your summary.
No, it is still a very beautiful face, so don't be scared to show showing it. Okay. Honorable members, does this bring us to the end of our deliberations? Anyone wanting to say something? Can we close the meeting and request the committee secretary to prepare the memorandum setting out the request that the EFF made, seconded by the DA, and then the ANC also agreed with that proposal by the EFF and the DA. And then, yeah.
I think what you have not addressed, Chair, is the question that Dr. Mulder asked, and whether it's a full report, and if it's a full report, what must we expect in the report to be in the report, or is just I think you called it a memorandum or something that is very specific, crafting a resolution form. Can we get clarity so that we leave here with an idea of what is to expect? What to expect? Sorry.
I will speak subject to correction. I think if it's a report, it can only be an interim report because we have not concluded the deliberations. But what we need is the memorandum requesting an extension. That's what is more important. We can attach an interim report, but the report cannot be the final report. I speak subject to correction. Honorable Nuku.
Chair, yeah, I think we were proposing 60 days, so I just want to put that on record. But I just want to, as a parting shot from our side, is I thank you that you stood up for the legal services this time around. We are really thankful, and we hope that you will continue defending the legal services in our meetings. Thanks very much.
I'm not defending them because they are not charged with any offense. I'm just restating the principles that, but anyway, we can put the same thing in different ways. Let's leave it there. Honorable Advocate Bonani, can you address the last question? Is it a report or a memorandum or an interim report plus a memorandum requesting the extension?
No, Chair, the problem with an interim report would be that then the committee will have to reconvene and adopt it. And, as indicated, the deadline expires today, so there might be no time for the committee to have it. Yeah, I'm just sharing an example of a memo that we used previously. So that members can see what we just outline what the committee has done so far and what is remaining, and then thereafter request that the committee grants us an extension.
Okay, no, I think members should agree with you that we can't go the way of an interim report because it has to be adopted. We don't have time to do that. And it's not even essential that we put in the report because the report is not required for the sake of getting the extension. So we'll go the route of a memorandum. And we have seen the example of a memorandum. Honorable Melder.
I just wanted to say I agree with you, Chairperson. There's no possibility of a report, either interim or final. We can just send a memo and ask for an extension. Thank you.
Thank you. Honorable Lesoma.
Thank you very much, Chair. I think we've got clarity now that we'll submit a memo, as correctly you said. But it's that one, we have dealt with that one concluded, Chair. Can I say something? To say that I'll request that the MENCO sits and tabled and come with a proposed program that will deal when are we going to adopt the minutes and all that, so that by the time then we come back, we don't also go back to the outstanding issues that there's no need to be outstanding. Thank you very much.
Thank you. That's a very timeless intervention. We'll request Advocate Ramanu to convene that MENCO and then already produce a kind of a program as to what we must do by when. Thank you very much. Honorable Gumede, you'll be the last to speak.
Well, Chair, I'm sorry to take you back, but I am of the understanding it depends which office at times the report or the request goes to. It looks as if we're all confident that we will be granted the extension. Assuming we are not granted the extension and there is no report that has been forwarded, what do we do in such circumstances? Thank you, Chair.
Honorable Gumede, I think that is a very good academic question, a necessary question. But given our circumstances, let's agree that this request will go to the chair of chairs and he will process it. But I think that the leadership of Parliament will appreciate the significance of this matter and that we cannot allow a situation where this process collapses, because if it collapses, it will be disastrous for the country. And we will also talk to them on the sidelines that this is the gravest matter of national interest. We cannot take chances. They really have to consider our application seriously. Honorable members, can we leave the matters there to give the administration an opportunity to prepare the memorandum and submit it timeously? Hello?
Okay.
Yes.
I'm sorry to take you back, but I just wanted clarity so that when I draft the memo, then I reflect what the committee is saying. There's a view from Mr. Shibambu there that says that this issue, or maybe let me start by saying that the committee extensively discussed the issue of the mandate. There was a view that the committee is outside of its mandate, and then we should be going to the House to request that we be allowed to make amendments in other sections. There was also a view that we are still within the mandate of the committee. So I wanted to just to get an understanding of whether when we write that memo, should we include that the committee also wants to amend other sections of the Constitution, or just leave it as
No. I think Honorable Shibambo mentioned three things: nil compensation or without compensation, and removal of the cutoff date, and the state custodianship. Those are the three issues. I think let's confine ourselves to that and not raise many other things.
Okay, noted, Chairperson.
Can I come in?
Yeah.
Yes. In other words, you must deal with the sections that have already been proposed for amendment, either by the ANC, EFF, and so on. I think in that way it gives you clarity of what sections are up for further discussions. Am I right, correct, in saying
no,
that?
you are right, and that's why Honorable Suma correctly asked that you restate the position. That you are perfectly right, and let's leave the matters there.
Thank you so much, Prof.
Chairperson.
Okay, Honorable Dr. Mulder.
Chairperson, I don't think we can do it that way. With all due respect, we cannot ask extension to accommodate the views of two political parties. We cannot do that. We can only ask an extension for 30 days because the committee has not completed its work, full stop. We don't have to indicate that we want to discuss about this, we need to this. We ask to extend. We as a committee knows what we want to do, but you cannot ask Parliament to give extension because two specific parties are still negotiating with one another.
Honorable Dr. Mulder, I offered all political parties to put issues on the table, which they did not, but I want to accommodate you by saying we can mention those things and say, and any other matters that parties may raise, and leave it at that under general. I think Dr. Lotrick also suggested something of that kind. So I'll leave it in the good hands of the secretary to accommodate what you are saying. Thank you, Badiba. But we must also put on record, this is not a two-party process. It's not EFF and ANC. It is a process for all the parties in the subcommittee. Thank you very much. Can we adjourn the meeting?
Long live the chair. Thank you.
Chair, my hand was raised before you proposed to adjourn the meeting.
What were you going to say? Because we are running out of time.
Chair, mine is very short. I just want to say that I support Dr. Mulder on the issue that we cannot be proposing to request for a extension on behalf of one party. It's definitely.
I've already ruled that out. I've already ruled that out.
I just want to.
That out.
I just wanted to make a.
I've not accepted that.
Thank you.
Okay, thank you.
Thank you, Chair. Bye-bye. Meeting closed. Thank you so much.
Are you chairing the meeting now, Lesoma?